What games are being played, Mr. Carson?
I have no interest, time, or energy to continue this charade.
I haven't calculated it.
You wouldn't have calculated that before today?
Don't talk over me. I'm not going to allow you to berate anyone in this courtroom, nor will you disrespect me or the process.
Save yourself the time. Have her facts.
Don't tell me what to do, okay?
Excuse me?
You control your own mouth. Don't tell me what to say. I might work with the lady sitting next to you, but you don't talk to me like that.
So we've got an entitled brat today who thinks he's above the law, that he can say whatever he wants, however he wants, and walk away without consequences. From the moment he opens his mouth, you can tell he has zero respect for the judge, the plaintiff, and honestly, the whole process. This is one of those cases where you'd be smart to just shut up, write it out, and pray you don't rack up extra charges, but nope, not this guy. Instead, he's running his mouth non-stop, making enemies of literally everyone in the room. The arrogance is unreal, and the lack of self-awareness is almost impressive in the worst way possible. It's like watching someone set their own house on fire while bragging about how fireproof they are. Do you think this is stupidity, entitlement, or both? Let's go ahead and dive in.
Mr. Carson, you can remove your hat. This is the court proceeding. Today was the date scheduled for a discovery or a debtor's examination. Were you able to complete your exam?
No, Your Honor. Mr. Carson refused to answer any of my questions. He said he's not going to play games with me.
What games are being played, Mr. Carson?
Well, Your Honor, when I was previously there, I received a verdict by you that I believe to be emotionally charged due to your frustration with my inability to complete the tasks of a lawyer. I attempted to get a lawyer through the system. They denied me. I had to show up last minute unprepared, and things didn't go my way. So I figured, I'll do the process. I'll try to appeal it. I go downstairs and I'm told I have to pay $200 and some to even have a chance to get a fair trial or verdict. I'm having one individual who was emotionally charged at the time decide what has to happen with me instead of a jury of my peers. And now I'm being told I have to produce all my financial statements, documents, vehicles, titles, all this. And I have no interest, time, or energy to continue this charade. I've lost several days of labor.
Let me stop you because I'm just getting updated on this case. This was a landlord-tenant hearing that I presided over. Did you demand a jury trial?
I'm sorry?
Did you make a demand for jury trial in the landlord-tenant?
I requested, yes.
You made was there a demand on
in written? I didn't put anything in writing. I did request the trial. I went downstairs and asked what my rights are, and they said to proceed any further past your decision, I had to pay $200 and some to even try. I did not have the money at the time, nor would I have it.
But sir, I asked you to let me get caught up. I'm trying to see if you have filed a jury demand. Let me also be clear. I don't make decisions because I'm emotionally charged.
No,
don't talk over me. Don't talk over me. Just because I won't let you run my courtroom does not mean that I am emotionally charged. There's order that will be set in the courtroom, and you will not talk over people. You will present the evidence. I am absolutely fair and impartial, and you then have the right to appeal my decision. Just because you disagree with the decision doesn't make it impartial, okay? And if you don't follow, there's rules in place that I don't set as to how you file such appeal. If the clerk's office told you what you needed to file to move forward with the appeal, then that's what you needed to do. But I'm going to make it clear on my record that I did not make a decision in this case based on any emotions. I have no reason to be emotional about your eviction, sir. I'm not being evicted. So if you keep talking over me, this is probably what you did the last time. It's try to cut me off. Yeah, and you're shaking your head. So that's not me being emotionally charged. That's me not allowing you to run my courtroom. You don't talk over people. You have a question.
Yes, I was just speaking and you cut me off, but I'll let I
run the courtroom.
Okay, I understand.
Did you notice that?
May I finish, Your Honor, please?
Yes.
Okay. At the time of the last proceeding, I interrupted you. I apologize. But the second or third interruption, you stopped me in the middle of my sentence and awarded them the decision. You know what? You were like, you know what? decision for them. You didn't specify why. It was just an emotionally charged because you were frustrated with my inability to complete the tasks of a paid lawyer.
The entertainment value in this guy's voice is unmatched. It's that kind of strange blend of smugness and whining that makes you want to laugh and cringe at the same time. He's sitting there acting like he's in charge, like the judge is just another player in his personal drama. That's mistake number one. The courtroom is not your stage, it's the judge's arena, and the second you forget that, you've already lost. What really stands out is how emotional he is. Every decision that doesn't go his way gets blown up into some kind of personal conspiracy. In his world, if he doesn't win, it must mean the entire justice system is rigged and against him. That's not just delusional, it's dangerous, because once you start convincing yourself of that, you'll never accept a responsibility. And here's the irony, there's actually a legal outlet for people who think they've been wronged. It's called an appeal. That's literally why appeals courts exist, but instead of using the process, he's stuck in a cycle of arguing, shouting, and cutting off the one person he should be respecting the most. The judge doesn't need to scream to be heard. Her words carry the weight of authority by default, so when he talks over her, he's not just being rude, he's showing he doesn't understand the power dynamic in the room. That's like bringing a squirt gun to a gunfight. You're outmatched before you even start. And you can hear the judge's patience start to fray. She's trying to stay professional, but her voice is tightening, and that's a warning sign. Once the judge starts losing patience, it's only a matter of time before a contempt charge comes flying down, and honestly, I wouldn't blame her one bit if she hit him with it. The wildest part is, he doesn't even seem to be aware of how badly he's hurting himself. He thinks he's proving a point, but all he's doing is stacking the deck against his own future. At some point, you almost want to ask him, are you here to defend yourself, or are you here to self-destruct in the loudest way possible?
I have evictions every single week. And the majority of my evictions are people who do not have attorneys. I don't know if you know that. Over 75% of our cases do not have attorneys representing them. I do not get frustrated with your inability to do the task of a lawyer. Where I will get frustrated and where I will not tolerate is if you think you're going to yell out or yell at the other party, yell at me, and you're going to act a fool in the courtroom, I will no longer allow you to be heard. Just because I cut you off and make a ruling does not mean that I ruled in their favor because I was frustrated with you. I was going to rule in their favor anyways because of the facts of the case. I was allowing you an opportunity to be heard. But when your opportunity to be heard becomes a hindrance to the procedure in the courtroom, then I have to terminate the hearing. And so if you want to proceed in any other manner, I don't know what your rights are now at this point as it relates to your right to appeal. You may have exhausted that time frame, but you're going to need to appear in person. I'm going to reset this since you refuse to comply with the court order to participate with the discovery proceeding, because this is an official proceeding. This is not your option. You have to participate in the proceeding because you have a judgment against you, and the plaintiff has the right to figure out how they can recover on that judgment.
Can we
Do
speak?
you understand that? Yes, you may.
Well, we tried to tell her, like, the funds, we can pay them. Like, we have no problem with that. We tried to tell her the same thing.
What is the past due amount?
It's roughly somewhere in the ballpark of $10,000 with interest, Your Honor.
And
I asked him if they could make a payment in full, and he wanted to argue the merits of the judgment itself. I never heard an indication there would be a payment in full. If there's some sort of payment plan, I'm happy to discuss that once I get my questions answered, because they have made no efforts to make payment on this, never reached out. We've tried multiple different avenues for the information that we did have on where we thought they banked and where we thought they worked. So I would need answers to all of the debtors exam questions, and then I'm happy to work out a payment plan. In the event of a default, then I can pursue other arrangements.
Okay. Are you in a position to pay in full the past due amount?
I'd prefer a payment plan. I would like to see what the interest is and what the original charges are. I was never actually formally presented with any numbers, despite what she had just told you. Until we were physically served for this court date, I had heard nothing other than a couple of emails where they were denied requests to garnish.
Yeah, we haven't received.
That is literally the only thing pertaining to the case I have seen since I walked out of your courtroom, attempted to file for an appeal, and was told I had to physically come up with money to do so that I didn't have at the time. So I at no point was ever given a fair trial. I was given an opportunity to pay for one potentially. But I've received, like, the judgment is for, you gave them and rewarded them things they shouldn't have had. We weren't there. Like,
If you disagree with the court's position, you have the right to appeal. You failed to do that. I also want to correct the record again. You did not properly file any demand for jury trial, although being advised on your first appearance of how you have the right to a trial and how to file such jury trial demand. You did not file a jury trial demand. So if you didn't get a trial, that was on you.
Then I guess I misunderstood, and that goes back to me not being a lawyer and wishing that I had.
That does not go back to you being a lawyer. We made a video. We make a virtual presentation. It's a video that I play, and every courtroom in this court plays that video at the first appearance. Most of you all don't pay attention to the video. It tells you very clearly in very plain language, you have the right to a jury trial. And you can make such demand for a jury trial, and it tells you how to do that. You don't need to be an attorney to do that.
Sorry, go ahead.
I'm done.
This guy absolutely needs a crash course in respectful communication, because what he's doing here is the courtroom equivalent of juggling knives blindfolded. Rule number 1, never ever interrupt a judge. That's not just about respect, it's about survival. Judges hold the keys to everything in that room, the tone, the process, and ultimately the outcome. So when you keep cutting them off, you're basically handing them the rope to tie the noose around your own case. And then just when you think he couldn't make himself look worse, he gets caught in a blatant lie. He claims he doesn't know how to handle a jury trial, but the judge shuts him down with the facts. And suddenly the mask slips. That moment kills his credibility, because once a judge catches you lying, every single thing you say afterwards is under suspicion. And instead of owning it, he doubles down with excuse after excuse, piling them up like sandbags against a flood that's already sweeping him away. Now he's playing the "I'm not a lawyer, I don't understand the law" card, as if ignorance is some kind of magic shield. But here's the problem. He's also acting like he knows everything in the room. Smarter than the judge, smarter than attorneys, smarter than the system itself. You can't play dumb and genius at the same time. It just doesn't work. All it does is make you look slippery, like nothing that comes out of your mouth can be trusted. And judges hate that, because their entire job relies on credibility and clarity. Watching this is like watching someone punch holes in their own lifeboat while insisting they're a master sailor. He could have kept it simple, stayed respectful, and maybe earned a little sympathy, but instead he's building a reputation in real time as the guy who thinks the rules don't apply to him. And in a courtroom, that's a reputation that always comes back to haunt you.
Can she produce an actual number, or are we going off of what she thinks?
So I'm asking for what's in the judgment plus whatever interest is, and I haven't calculated it.
You wouldn't have calculated that before today?
You can do one of two things, sir, because I'm not gonna, the games that are being played, I do not believe are on the part of the plaintiff at this point. You can participate in good faith right now in the debtor's examination, provide the answers to the questions, which are under subpoena. You've been ordered to court for this purpose. Or I can reset this and order you to appear in person. If you fail to do that and to comply, then we have to proceed to a next step, which is a bench warrant. And I don't think you want a bench warrant over a civil matter. So it's in your best interest to comply. It sounds like she's willing to work with an installment payment order, but only after she gets the answers that she needs to figure out how they're going to recover on this debt. So how do you want to proceed?
I'm sorry.
I'm sorry.
I asked him if he had any of the documents that there were, in addition to information, the documents, plenty of documents that were asked for, and he indicated that he wasn't going to produce those. So I would ask him to appear in person with all of the documents.
Oh.
And I'd also ask that, Your Honor, that he return to a tone that is respectful. He has screamed expletives at me the last time we were here in court, and he's called me things today. And it's uncalled for and unnecessary.
I am absolutely clear that the emotional charging was not from the courtroom. I'm not going to allow you to berate anyone in this courtroom, nor will you disrespect me or the process. You can appear in person. I'm going to reset this date. You need to bring the documents that were ordered under the subpoena. If you fail to comply, the court will issue a bench warrant.
Your Honor, save yourself the time. Have her fax.
Don't tell me what to do. Don't tell me what to say. You instruct yourself.
I'll pay her
You instruct yourself, or you'll be in contempt of court. okay?
Excuse me?
You control your own mouth. Don't tell me what to say. I've already given you an
No,
opportunity.
Your
I'm
Honor.
now resetting this. I'm now resetting this. You can appear in person. If you pay in full, then they can move forward to make sure that this removes off of my docket. But do not tell me what to do. I do not tolerate your tone. This is how we got here the last time. That might work with the lady. That might work with the lady sitting next to you, but you don't talk to me like that. Not in the court, not outside the court. Do you understand that?
I'll pay the balance.
Thank you.
My phone number's on all of the court paperwork. You can give me a call and I'll give you a number.
Give me a new date.
September 4th at 1:30.
September 4th at 1:30, you said? Yeah, in person at the court. If you pays in full, you can provide evidence of that and have this removed from my docket. Any additional matters for the record?
No, Your Honor, thank you very much.
Save the
You're all
tax
set.
and money.
Mute him and remove him from my courtroom before he's in contempt.
Oh man, what a ride that was. This is the perfect reminder of why showing up to court with the right attitude and respect can make or break your case. Interrupting the judge is basically pressing the self-destruct button. You're only speeding up your own downfall. And honestly, this guy is lucky. She could have slapped him with contempt and ended things on the spot, but instead she gave him way more rope than most judges would. If it were me in her chair, my patience would have snapped it about 10 minutes earlier, and this video would have been a whole lot shorter. That balance between patience and authority is tough, and she walked the line well. The bigger issue here is what this behavior says about respect for the legal system. If more defendants acted like this, courtrooms would be pure chaos. Do you think she went too easy on him, or did she handle it just right? Let me know your take in the comments. Thank you so much for watching. Don't forget to like and subscribe, and I'll catch you in the next one.